Good afternoon, everyone. Thank you, Dan, and glad to have everyone on board for today's webinar. My name is Angela Davis. I'm with the law firm of Gerard and Davis, and as you see there on your PowerPoint slide opening, that I represent a variety of counties and cities across the state, and then we do a lot of work just generally for governments all over the state of Georgia on special assignments, on investigations, which we're going to talk about today, and also, of course, serve as the helpline resource for ACCG. So if any of you are counties who have ACCG insurance, then that's a great resource for you to call me, and we will help you on ACCG's dime instead of yours. So with that as an introduction, I'm thrilled to be here. One thing I do want to share with you, Dan has assured me that it doesn't look too bad, but we had a flood in my office this week. A pipe burst and flooded my office and a good portion of our main floor. So I am sitting currently in a storage closet, have a little desk, and I did take the boxes down behind me, so hopefully they're low enough that you can't see them stacked up behind me. But if you could see my surroundings right now, you would get a chuckle because it is pretty interesting, but it is allowing me to have a little quiet spot to focus on you in this important topic we have today. So hopefully you won't mind my surroundings for this one time. So let's just go ahead and jump into this. When Dan and I were discussing programming back in the summer, we talked about the concept of getting back to school and thinking about back to basics. And so that's what this three-part series is intended to address, is basics of human resources law, basic things that you're dealing with every day, whether you're a human resources professional or whether you're a manager or supervisor dealing with personnel. It is a three-part series we're doing over the next 3 weeks, and you don't need to attend each one of them. We'd love you to, but each one will stand on its own. And if you aren't able to attend some of the others, then perhaps you could get the recordings or the PowerPoints, as Dan mentioned, will be sent out each time. But our goal here is to really build some basics for you on what we see as the most critical claim-based aspects of human resource management. And so we're starting today with investigation of disciplinary matters and harassment claims. The next segment in the series is going to be on disciplinary, how to discipline, the do's and don'ts, and also the what if you don't, which is going to deal with like negligent retention as well. And then the third of the series will address grievances and appeals. So after you've investigated, after you've disciplined, and then you get an appeal or grievance process through your employee, how do you handle that? So that's what we'll be doing over the next few weeks in this series. So hopefully it'll be some information you can use. As I mentioned, we think this is a great material for anyone who's in human resources management, but it was also our goal with this series to provide you with some material that you could use within your own organization for training. And so it's not always convenient for you to have every one of your managers jump on a webinar at the same time, but we're encouraging you to take these videos and to take the PowerPoint. And if you don't have time to dedicate, an hour for your supervisors and managers to watch it, then I think the PowerPoint is done in a way that it could be useful as well, even if they just get a copy and flip through it. But we believe it could be great training material for your organization and for others who aren't with us today. So I get asked to do a lot of investigations. I get asked to do them and I get asked to review them. And candidly, I like to do better than review, because when you get a bad investigation, it can make it very hard for me to be able to recommend action. And so many times I get an investigation and I'll start reading through the investigation materials, I read through the interviews, and I've got a ton of questions, and I think, oh, I wish you'd just asked this, or I wish you'd have followed up on this, or what about these contradictions, and sometimes I can send someone back to clean up. Sometimes there's a process or a timeline that doesn't allow the investigation to be improved upon. So the goal today is to educate you and provide you with some tools so that you can conduct an investigation that will be solid and that will get to the core of answering any question you had, so that you can determine whether you need to take some kind of action based upon the underlying issue. And I think so many times you get these investigations that are just sort of mushy. That's the term I use. It's a real official technical legal term, mushy. And so my goal today is no mushy investigations. What we want to see is thorough, consistent, neutral, non-discriminatory investigations. And so it sounds like a tall order, and it is, but today my goal is to give you the recipe to meet that tall order. So let's jump in with all of that as our framework and our background and talk about conducting workplace investigations. So why do you ever launch an investigation? Well, there can be a variety of matters. I think the two core issues would be a disciplinary matter or a harassment type allegation. So on the first component, a disciplinary matter, you know, I'm sure you've had these come up. You may have a situation where you've got a supervisor who believes an employee has violated a policy. You may have allegations. I've even had allegations come from citizens that an employee is wasting time, misusing resources. You know, maybe they see the county car parked at a home during hours, you know, general county hours. I've had that come up before, and so we launch an investigation. So it may not be complaint driven, but it may be violation or disciplinary related driven, and that's what might kick off an investigation. And I think that could include, you know, any kind of misconduct violations of policy, whether it's your workplace violence policy, your alcohol policy, your vehicle policy, and on and on. So anything where you may have a cause to discipline, but you need to know more, then that requires an investigation. The second component, and the one that probably is a little dicier for you to handle, are those you get where you've got a harassment allegation. And it may be harassment based upon sexual harassment. It may be racially based, ethnically based, you know, age based. I've seen all those kinds of allegations come forth in the workplace. And those sometimes can be more difficult to investigate because oftentimes it's a he said, she said. There's a lot going on. It's very global as opposed to very granular. And we're going to try to cover how to do an investigation across all of those spectrums. But you will find as we talk about it, because I think the harassment type investigations are a little bit more difficult, a lot of what I say is going to sound like I'm talking about those types of investigations, and I am, but the way you investigate can apply equally to any kind of disciplinary matter as well as any kind of complaint-driven harassment allegation. So just wanted to point that out. So as we start today, I want to give you just some legal foundation. And this is probably the least fun, driest part of the seminar, so stick with me. But these are laws that you may not really have top of mind that should guide how you conduct your investigations. One of the first and biggest, most important laws that we should be aware of when you're getting any kind of complaint that launches an investigation is the Georgia Whistleblowers Act. And I've given you the official Code of Georgia citation there. Generally, you've probably heard of this before, but generally what it does is it protects public employees in reporting to their employer possible activity that could be fraud, waste, abuse, misconduct, that kind of thing. So the idea is you want to protect the employee who wants to blow the whistle on bad conduct and make sure that they will not be penalized as a result of blowing that whistle, so to speak. So just quickly, I want you to understand some things, and these are really just kind of potholes you don't want to step in if you're conducting an investigation, because there is a law that guides some of these things. So the Georgia Whistleblower Act prohibits public employers from doing these things. First of all, this is something you may not be aware of, disclosing the identity of the employee after you receive a complaint if the public employee has not given written consent, unless the employer determines that the disclosure is necessary and unavoidable during the course of the investigation. So the idea here is someone should be able to, with some reasonable sense of confidentiality and privacy, bring to light these concerns and allegations against the government without having their name spread out all over the place. Related to that, if the employer does determine that the disclosure is necessary, the employee should be notified in writing at least 7 days prior to such disclosure. So for all of you guys out there who I'm sure are really, really smart on these issues, you may be thinking, well, gosh, what about the pesky Open Records Act? What happens if there's a protection to a whistleblower's identity? What if I get a request under the Georgia Open Records Act? Well, I think you have to read these two together the best you can, because this does give some sense of protection. What my advice would be is if you get a Whistleblower Act allegation, then I would, at that time, need to make a determination. Do you think it's going to be important to use the identity of the employee's name? Usually it's really not. But ultimately, I think with an Open Records Act request, you could produce the complaint if that's what you're asked for, and you could redact the employee's name. Again, though, if you are doing that, I would try to push out your Open Records Act request to 7 days, just to be careful under the Act, the Whistleblower Act. And of course, under Open Records, you have 3 days to respond. But on that third day, you could say that you're giving a time estimate. I don't want to go too far to Open Records, but I think there's a way to read the two together. But I just wanted you to be aware of it because it's maybe something that's kind of one of those hidden requirements that's not top of mind for you. Also, the Whistleblower Act, in addition to those identity issues, also prohibits an employer that's a government from making, adopting, or enforcing a policy that would prevent an employee from disclosing a violation of law, rule, or regulation. Also, the Act prohibits retaliation, which would seem obvious, and prohibits retaliating against an employee who participates. So not just the employee who brings the allegation, but also those who may participate in the process. As a matter of timing, you can file a Whistleblower Act claim against the government within 1 year after discovering any retaliation, or within 3 years after retaliation, whichever is earlier. So ultimately, that's what we worry about, is whether we have any liability to that employee who blew the whistle, if indeed they believe they are mistreated later after the investigation. And then what that employee could win in any lawsuit that favorably ends for them. They can get an injunction against the government, reinstatement, benefits, seniority rights. I won't read everything there, but basically the whole smorgasbord of relief that plaintiffs can get, including attorney's fees if they prevail. So the Whistleblower Act in Georgia is a pretty good hammer that should lead all of us to be real concerned that we're in compliance and that we're avoiding retaliation. That's the main goal with the Whistleblower Act, is to protect these employees who come forward and you launch investigations related to their complaints. There's one more law I want you to know about, and this is also a Georgia law, effective just recently in July of this year, and it provides a similar cause of action. They don't call it the Whistleblower Act, but it's basically the same thing for employees who may have been retaliated against based upon opposing, reporting, or complaining about sexual harassment. So it really takes the whistleblower concept of protection against retaliation into the sexual harassment arena. It includes those who complain as well as those who participate or provide information in connection with any kind of sexual harassment investigation. And the statute of limitations in terms of the 1 year versus 3 years, and all the remedies as applied under the Georgia Whistleblowers Act also applies under this new Georgia Sexual Harassment Retaliation Protection Act. So those are sort of some big picture legal issues that I want you to have in mind each time you conduct an investigation. But again, they're protecting and focusing on ensuring that there is a freedom in your organization to bring these complaints, to launch these investigations without any threat of reprisal or retaliation against employees. So you don't need to get too mired up or too worried about them as long as you're ensuring that you're not engaging in any kind of retaliation. So with that as a legal foundation, I want to jump now into just sort of the nuts and bolts of the process. How do you conduct an investigation? What are some best practices? So the first thing I would say to you is you should have a complaint process. Now, even if it's for disciplinary matters, I think it's important to have an investigation process, because I've had this question come many times. You know, an employee has done something, the supervisor thinks it needs to be investigated. It's not coming as a means of a complaint, but they want to investigate. And then the question does, well, how do I do it? What are the parameters? And so if you have a complaint process, an investigation process in your handbook, I think it's very helpful to look at that and ensure that it's expanded to include opportunities to report complaints, not only on sexual harassment and discriminatory harassment, but I list a few other things here, like drug and alcohol, workplace violence, weapons, as well as of course, sort of the big two, discriminatory and sexual harassment. And also consider if your complaint and investigation process in your handbooks make it applicable for all disciplinary matters. That's a really easy fix. If it doesn't, to just broaden it out to show that this is how, you know, or an extra paragraph that says we will also investigate any disciplinary matters pursuant to these policies. It's just always good to give yourself a playbook when you're going through an investigation, so then an employee can't allege that they're treated differently. You know, you investigated more aggressively with this employee, you didn't do that with me. It gives a playbook and a process, and you follow it for everyone. Now, the big thing is here, if you don't have anything in your handbook, you need a process. You need a complaint opportunity. You need an investigation process. Now, as to the specifics of the complaint process, I want to speak just a little bit about that. So I'm going to focus now on the complaint-driven investigations. Whenever you have a process in your handbook, and again, first step is you need one in your handbook, but you want to allow multiple avenues to make your concerns known. So think, for instance, if the complaint process is report to your supervisor, but it's the supervisor who's the sexual harasser, then you need to make sure that there's an opportunity for the complaint to go around that supervisor according to policy. So your policy should say something like, report to your supervisor, or if you feel more comfortable, you can report it to the department director, the applicable local official, the county manager, or whatever you deem to be an up the chain reporting opportunity. You know, ideally it's going to go to the supervisor, but sometimes there's reasons that makes that uncomfortable, and you don't want an employee to not feel that they can bring forward their complaints. You also want to ensure in your complaint process that there's some kind of built-in timeliness. I know timelines always kind of bite us sometimes, but I think it's still helpful. It keeps us all on track. So I think as much as you're going to want, you know, complaints to be brought within a certain period of time of the incident, then you're going to want to have at least a goal of investigations will be completed within whatever you think is reasonable with your resources, you know, 14 days, 20 days, 30 days. But I always say give yourself an out, you know, that it could be extended in the reasonable discretion of whomever's doing the investigation, whether it's the county manager or the investigator, if it's an outside person, so that there's an opportunity if you are finding yourself needing additional time that you can extend it. But I think ensuring some kind of timeline so there's an expectation of completion is helpful. I think it's also helpful to ensure that there's some follow through at the end of the investigation, and that can be provided in the complaint process. It's important to state in your complaint process that you will maintain confidentiality on a business need to know basis, but make sure that you don't overpromise. You know, I hate seeing this because very often I will hear someone, you know, will make a complaint and will say, this is strictly confidential, only between you and me. You know, when I read that in the email or I see that in a memo, it just kind of hurts my heart, because in government, just nothing's really that confidential because everything's subject to the Open Records Act at some point. So make sure your policy does not overpromise on that point. There could be an opportunity for everything to be ultimately public if requested under open records. And then your policy needs to state that you're going to apply it consistently, and then you need to do that. Remember, you've learned the law now on whistleblower. You don't want to retaliate or allow even the hint of an appearance of retaliation to occur against the complainant or anyone who participates in the investigation. By the same target, there shouldn't be retaliation against even the target of the investigation until it's determined that there's something substantiated there, you know, in terms of at the end of the investigation. Now, you've got a solid policy that should include those things that I've just mentioned. So now when you get a complaint, let's talk about what happens next. So the complaint usually in these days is probably going to come in via email or in writing, but I think it's important to sit down with the employee, and I encourage you to do that if you can with a witness in the room. So it's not just a one-on-one, but there's at least 2 county officials with the employee to indicate you've received the complaint. You should have just sort of like a bullet point script that you use every time. Explain that the concerns will be taken seriously, they will be investigated thoroughly. I've seen this time and time again. When an employee believes that they're being heard and that they're being fairly treated as a complainant, sometimes that's just almost enough. And they don't necessarily need an eye for an eye and tooth for a tooth, or they're not looking for a claim against the county. Sometimes they just truly have a good faith need to be heard. And so I have seen folks do good investigations where I think they've warded off claims, and then I've seen people really not approach their employee complainant quite as well, and they've really just fueled the fire, and we ultimately get a claim. So this is your chance to really chart your destiny. So when I say have a little script, I'm not kidding. I don't think it hurts to just have a set of procedures. You know, you're going to have your policy that the public sees or that your employees see, but have an internal procedure where here's your intake, here's your complaint meeting, where you tell the employees these things. You should always consider whether there's an employee that needs to be put on administrative leave or transferred or shift change, something to take the complainant away from the targeted harasser or the person they're alleging to be the troublemaker, if you will. So the victim and the harasser, I'll just use those terms just to be general. You don't want to keep them working together if you're getting serious complaints about sexual harassment or racial discriminatory harassment or any other kind of allegations like that. You want to make sure that those two people are not forced to work together during the process of the investigation. So administrative leave is a good option for the person who's the target of the investigation. It's good for a couple of reasons. It removes that person from the workplace, so that should limit the ability of that person to tamper with the investigation or to, put any pressure on witnesses. But also, it importantly just physically removes them from being involved with the so-called victim. If administrative leave is not real practical because you're short-staffed and you have limited resources, I think the far multitude of these complaints tend to come out of law enforcement and fire. And if that's the case, you have a lot of opportunity to move people around on shifts or stations. And so I think you should consider that. But I think making sure that if an employee is complaining against their supervisor, you don't want to leave that employee working under that supervisor through the duration of the investigation. You need to take it seriously and remove the person. Now, hopefully you have something in your handbook that provides for administrative leave that's not a stigma. Because when you get a complaint, you don't know if it's true or not, and you need to approach it that way. But I think as a matter of precaution, you do want to remove those two employees to separate the two employees. And some may feel that it's a penalty to be administratively placed on leave or to be transferred. But I think that is a reasonable step to take. Now, we'd consider whether it's administrative leave with pay. And that, again, is why your policy probably wants you to have a quick investigation period, because if you have an employee sitting at home being paid, you don't want to let that stretch out. You also want to not discourage an employee. So if someone comes in and wants to file a complaint, as much as you probably don't want that extra bit of work, or you don't want to open that can of worms that may come out of an investigation and a new complaint, never discourage someone from filing. Very often I see ultimately, lawsuits where there's the story, and I went to HR and HR really tried to gloss it over and kind of just scurried them back out the door that, go play nice and, come back if you need me. And you don't want to do that. You need to hear the complaint. You need to let them feel heard, and don't discourage them, because if they've come to the point of coming to you, it's not just going to go away. And then don't let the employee just come and complain or file a complaint and then say, oh yeah, never mind, I'm not going to follow through. That happens all the time. I'm sure you've seen that. We can't have that, because once an employee's gone on record, we're on notice and we can't ignore that. So you would have to just explain, look, you have a complaint. I understand maybe you're uncomfortable with going through this process. We'll make it as painless as possible. We'll protect, confidentiality as much as possible. But now that I know these things, I can't leave them without looking into it further and ensuring that you have a good and safe workplace. So don't let that employee, give you that complaint and then try to rip it back and act like everything's fine, because it'll come back to haunt you. I've seen it a million times in lawsuits. Document any conversation. So this should be sort of a part of your internal script and playbook, if you will, your internal procedures, where you follow up and you just, you had the intake interview, you've explained the policies, You document all of that, and you may even consider whether you want your complainant to sign something saying, you know, the complaint's been received, I've had my initial meeting, I acknowledge and understand that my complaint will be processed. Just something simple like that. And then you want to explain the process to the complainant. You know, many times we see complainants that get you kind of disgruntled in the process. I actually have 2 IAs from 2 sheriff's offices, different locations, on my desk right now. And one of them, I'm reading through like some emails, and it's the complainant who is asking about the process. And you see her increasingly, you know, day after day, and unfortunately this one's gone kind of week after week before I have come to learn about it. It was a long investigation, and you just see her ramping up. You know, she starts kind of cordial, and then more and more she starts getting suspicious about the timeline. And there's probably nothing to be suspicious about, but not involving the employee who had complained and not giving them any sense of what's going on can really create an additional disturbance for you to have to deal with. I had a complaint process that I've reviewed recently, and I commended the county manager, and I heard Greene County was on the line, and it was from Greene County, and they did just a wonderful job of letting the employee know, you know, I've conducted some interviews, you know, someone's on vacation, I've got some scheduling issues, I'm rescheduling for this day, and just kept the employees completely involved and aware of what was going on. And that's just an assurance to someone that they're being taken seriously. They're not just in the dark wondering what's going on, because that sense of unknown can create some consternation and sometimes can really heighten the complaining party to really feel like even the county is not helping them or not on their side, and then you become part of the adverse party. So, question I get all the time, who should do the investigation? So you've got a lot of options. Very often the human resources director will do an investigation, or the county manager. What you need to think about, though, is if you have a grievance or an appeal process, then that may chart your course a little bit about who does the investigation. Because if ultimately the decision maker on the disciplinary matter is going to be the HR director or the county manager, then you need to keep that in mind, because obviously they can't make a neutral decision in a grievance process if they were the ones who conducted the investigation and applied any disciplinary action. So just think through that, how it fits within the overall framework of your process. Another option, of course, is hiring a third-party investigator. I think that's your ideal situation if you can, but it's expensive. You know, it doesn't have to be a lawyer. I do a lot of outside investigations, and I think having a lawyer is super helpful, because you can do an investigation then that should be packaged up with a bow for any claim that could come later. But, you know, mindful of resources, and sometimes you can't afford to do that. You certainly can't afford to do it on every little investigation. So consider, you know, who you might have within your organization, and sometimes an internal affairs unit. You know, I had one county who had an internal affairs unit in the fire department, and they did a lot of investigations, even if it wasn't fire-based, you know, and so that's something to consider. Or whether your sheriff's office or your police department has an IA unit that would be willing to assist HR, even if it's not within their department. They are pretty equipped with knowing how to question witnesses, knowing how to build these IA reports, and they can be a really good resource. And then short of a third-party attorney, there's often third-party former HR directors. I have a couple that I will call on from time to time who have retired, but they certainly know HR, and importantly, and most important of all, they're an impartial party. And that's the biggest goal you have here, is impartiality. I had an investigation not too long ago, and I'm reading through it, and I think it's really well done. And then before I get through and make my recommendations, they send me like a complaint about the investigation. And the complaint was that one of the individuals who was sort of in the middle of all the allegations, not really the targeted bad guy, but very, very involved. It was his wife was the one doing the investigation. So obviously that did not look very impartial, because she is going to believe her husband, and that led the complainant to feel like that she had gotten, you know, home cooked on this investigation. So just really think through, you know, you need to look at the complaint as it comes in, look at who all the potential witnesses may be before you ever assign that or commence the investigation, because I'm not so sure they realized that on the front end, because I think they were sort of mortified when they realized it later on in the process. But you got to really think through that, because that really kind of tampered and really tainted the whole investigation to have that family relationship between the two sides. I apologize. My throat is dry. I think it's part of my storage closet dust that's around me, so please forgive me. So now you've taken in the complaint, you've decided who's going to investigate, and so let's launch it. So what next? I think the most important first thing to do is to notify the target of the investigation. So we don't want to be, running around investigating in secrecy. That doesn't help anything. You want to notify the target. So that person, I think you send them, I think it's good to document it. You can bring them in, again, do it in twos, always in twos, as opposed to a one-to-one meeting. I think it's nice to have a document where you say, we've received a complaint, we are going to be investigating this. If you can frame the investigation, I think that's very helpful in terms of the scope and the issues to be considered. That kickoff document, as I think of it, to the target employee, should emphasize the importance of cooperation and truthfulness, and also should indicate, as you did with your complainant, that you will respect privacy to the extent possible and confidentiality. Again, you don't overpromise that. And as you start to implement the investigation, you want to do so in a way that's going to minimize the disruption. So, bringing in the target employee and commencing the investigation, it's helpful to do that in a manner that's not just, on center stage for everyone. Whether it means doing it in a low-key conference room as opposed to, calling them over an intercom. I had this happen recently. In fact, it's one of the ones on my desk. In the complaint, it's just raising Cain about it. I think it was very innocent, but the sheriff over their law enforcement band, I think they call it band, is sort of their, it's a communication device that they make announcements on. And he made the announcement that there was internal investigation kicking off, and he asked everybody to cooperate and, appear promptly for interviews and so on and so forth. He didn't identify the name of the complainant, but you know how things like that go, word gets around super quick. And so she has just called that up a million times over, that she's been ostracized by him making this announcement over their law enforcement agency-wide communication device. So think about how you can minimize disruption by not putting it out there on center stage. People are going to talk. It's hard to prevent that, although I'm going to give you some guidance on that as well. But do your part in ensuring that as you implement this investigation and you engage the target, that you're not putting this out there publicly more than you have to. Okay, interviews. So when you receive the complaint, very often you're going to get some documents from the complainant. My advice, even before you commence into interviews, is to make sure that you have whatever records that could be useful to you. And it so depends on what the complaint is. But if you get the complaint and it identifies, certain things happened at this time, well, you may want to get, the time records to see, where these people clocked in at that time. Sometimes it's a swipe card record that you can look and see, I've had that happen, something just so basic that there's an allegation that this occurred here and the people aren't even in the same building at the same time. Things like that. So I would gather your records to the extent you can before you even launch off into your interview process. But many times you don't know what records you need until at least you start with an interview of the complainant. So just be mindful of that. But let's assume that perhaps you're starting with this first interview. Now, that could be at that intake meeting, as I've referred it to it, as when you bring that person in, you explain to them about how you're going to conduct the interview and investigation process. But this could be a second meeting. You may need to get the complaint, explain to the complainant what you're going to do, but then you may need to review it before you're ready to sit down and do the interview. And in fact, that's really what I would recommend. Because if you do an investigation the correct way, you should be very prepared when you sit down with the interviewee and make sure that you know exactly what you're going to ask. You don't want to just be spitballing, because you'll never get to the bottom of it if you're doing that in an unprepared way. So I would start with the complainant every time, interview them in an effort to obtain all the facts. So the complaint you get is going to have the facts that support their position, but it's your job to ask them questions that will make sure you hear the rest of the story, even from the complainant, because many, many times they will sort of undo their own complaint, or many, many times they will make some kind of untruthful statement, as you will find out later through the process, and that's really important to know. You should ask the complainant, this is my third point here, about relevant documents, text messages, recordings. Ask them, do you have any of these things? What do I need to look at? What do you have that you can show me? If she talks about, yes, the chief, is texting me all the time, these really inappropriate pictures. Well, let's see them. Do you have them? Or I got a voicemail left for me. Do you have a recording? So when you hear those allegations, try to, in your mind, trigger, well, what kind of documentary, tangible evidence could exist that I could request, and request it on the spot and ask that complainant to provide it. I think it's important to get a signed statement from the complainant. And frankly, that's another thing that's not bad to do in that intake interview. So you've gotten a complaint. Sometimes the complaint will be the signed statement. But sometimes you'll get a complaint where someone says, I'm being sexually harassed and I'd like it to be investigated. And it's just that general. And if that's the case, then I think when you start into the investigation process, you should ask them for some more specifics, because it's hard to even begin an interview of someone if that's how broad their complaints are. Ultimately, your goal is to discover as much information as you can from the complainant about what they know, but then also get them to identify important dates, times, locations, the names of who they think might be potential witnesses, and then identification, as I said, of these tangible evidence items. The reason it's important to identify dates, times, and locations to the extent possible is they may give you a list of potential witnesses who they know will support their position. But it may be that once you know, okay, it was in this office at this date and time, then you can say, well, okay, she told me that Johnny, Bob, and Dave were there, but what about Mary, Sue, and Sally? I need to talk to them too, because they should have been in the same place at the same time, but she did not identify them as potential witnesses. So that's why you want to find out information, so you're not just taking what that complainant spoon feeds you, but you are doing giving yourself an opportunity to truly uncover all of the facts and all of the information. Now, I get asked this question all the time, should I record an interview? I think it's a great idea. If you have a recording, then there's no question about what was said. Sometimes, of course, that can stifle the candidness of comments. And so sometimes you just have to know your audience and whether that's going to totally defeat your goals of getting information. But I would recommend as a matter of practice that you record it. You're going to tell them you're recording it. You're not going to be hiding something, in your coat pocket. If for some reason you don't record it, then I think at a minimum, you need to summarize the interview and ask them to sign it. Because what you don't want is to be basing your ultimate next steps and your ultimate findings on what was said, to have them disagree and dispute that I never said that. So it's best to get them pinned down in the beginning so that they can't later try to disavow their own testimony. Because I have to say, many, many times, it turns out that the complainant very often is the one who may end up having a disciplinary action against them. Not as a matter of retaliation, but maybe because they provide untruthful testimony or various things. So just be mindful of pinning that complainant down in fairness for both sides. As you go through each witness, some that the complainant will identify, some that you will discern on your own once you hear the fact patterns, you should repeat the same interview process for each witness. I think it's really important that you have a list of questions and a list of topics that you go through, and I'm going to talk about that sort of in more detail in just a minute. But don't walk in just planning to shoot the breeze. You want to really have detailed notes, be prepared so that you get those questions asked and get the answers you need. I recommend always interviewing your witnesses separately. it's easy sometimes, you know, if you have, this happened on this shift. Okay, well, you know, efficiency might dictate, let's bring everybody in on that shift. I recommend against that because if you interview people all together, as you might expect, there can be a tendency for the narratives to just kind of blend. People will be less candid. You really will benefit from a one-on-one, even though it may take a little bit more time. Again, I think getting signed witness statements, any recordings, and then getting written confirmation of an interview signed by the witness. If you don't do a recording, I think all that's real important. In terms of signed statements, what could be a good practice is after you've interviewed the complainant and you determine your list of who you're going to interview, it's not a bad idea to send them notice that you would like to schedule this interview and ask them to provide you a written statement in advance of the interview. That can be helpful because then you've got their own words in writing about what happened, and you can kind of cross-examine them based on that. It gives you some framework for your interview, and then also you've gone one step into having it documented as to what they might want to say. So signed statements before you interview the additional witnesses can be really helpful. So at the end of the process, the last person, in my opinion, should be the target employee. Doesn't mean that you might not go back and capture other people after the target employee, but I think you want to hear what everyone says before you get to the target employee of the investigation. You're going to repeat the same interview process, and I think it's important to make sure that you either record or give them an opportunity for a written statement or summarize back to them and have them sign it. So again, you want to pin them down on their testimony. That's the goal, so that they can't, you know, allege that you didn't say what you say they said. I'm going to have a note here about considering a Garrity warning. This could probably be a whole nother topic of conversation, so I don't want to go too far into this, but if you have questions, I'm happy to address them with you. A Garrity warning should be considered if what the allegations are implicate criminal activity. So if you have an allegation about theft or an allegation about, you know, some kind of assault under your weapons policy or something like that, something that you think ultimately could be a criminal prosecution, then what Garrity has to do with is allowing an employee to maintain their Fifth Amendment rights to not self-incriminate. You've probably heard that a million times. You know, I take the Fifth, plead the Fifth, where they don't have to testify. It's a constitutional right not to testify against yourself in a manner that would, you know, expose you to criminal prosecution. So if it's criminally based in any way, then I think you have a whole nother set of considerations that probably are outside of this topic. Happy to talk to you about them further though, but you just want to put that on the table. My preference of practice is if you know that you have a really significant criminal issue, I would put that employee on administrative leave and I would turn it over to the authorities. So if you think someone's embezzling, you think that they have stolen, I wouldn't try to do this interview investigation process. I would get it outside to an agency that's law enforcement based and put them on administrative leave pending that criminal investigation. But otherwise, if you think it could be implicated, but you're not sure, then what you could consider is just giving the employee notice that they have a constitutional right not to incriminate themselves, and that means that they would not necessarily have to answer your questions. I would never, never, never do that if you don't think there's any criminality involved, because it just doesn't apply. And when you do that, then your options are to say, well, if you choose not to answer my questions, then if you say that you're going to fire that person for not answering the questions, then that can give rise to a Fifth Amendment issue. Typically, Garrity says you don't have to give up your Fifth Amendment freedoms. It's your right not to testify. But if you do testify, we will give you immunity from prosecution. I don't love to do that because you don't know what may come out. So I don't like tying the hands of a prosecutor. In fact, there is actually a criminal issue. So I think it's better just to get a criminal issue out to your criminal authorities if you believe that's what's going on. And I wanted you to be aware of this concept of a Garrity warning in a civil investigation. And again, we can talk more about that in the questions and answers at the end if you have any further questions on that. So just to back up a little bit to the concept of interview questions generally. So how do you shape your, I've told you I want you to have a nice little list of questions. How do you do it? I think your goal is, for one, start by setting aside ample time to interview these witnesses. It takes a long time. I mean, so these investigations can really, really make a dent in your workload because they take time if you do them correctly. Ask open-ended questions to start with. What happened on September 5th? And then you drill down. I always think of it like a triangle. You start at the top and you're going to come down to a point. Ask open-ended questions and then follow up until you get into very specific granular issues on every single topic that's important or every single event that has occurred. It's really important to listen to what the witness is saying and then ask appropriate follow-up questions. It's very easy to be passive in the process, and you just can't do that. You need to engage with the witness. You need to be thinking on your feet, and you need to be listening and following up. Although a little bit unrelated, I have a daughter in high school who is on the newspaper staff, and she wanted me to listen to this interview she had conducted with one of the teachers for a story. And I was listening to it, and of course the lawyer in me, as well as I was a journalism major, I had to critique her. Of course, she loves that from her mom, right? But I had to share with her that there were times where she asked a question and he gave an answer, and there was an obvious next question that was begging to be asked, and she didn't do it. And it just really drilled that point home for me in reviewing that with her just recently. But that's what I see a lot of times in these workplace investigations. They've got a script and they ask each question 1, question 2, question 3, but sometimes the responses should elicit 10 more questions because they beg to be asked. So just make sure that you're listening, you're not passive, but you're active, and don't be tied to a script. But make sure that you're neutral. I've also listened to investigations or read investigations where it's clear that it almost felt like a law enforcement investigation, where I felt like the person, might as well have been sitting with their handcuffs on and a bright light shining on them, because plainly the investigator had an opinion about what the answers should be. And you don't want to do that. You want to be comfortable to challenge them if things don't make sense, but you need to be showing that you're neutral. And if something seems inconsistent, challenge them on it, ask the questions, but make sure it does not appear that you have a preconceived notion, or even that you make a decision about what the ultimate issue is while you're involved in the interview. Be neutral. A couple more things. Don't talk down to the witness or try to intimidate the witness. But by the same token, it's your interview and you control it. So I've seen some interviewers who are very timid and they let somebody just run all over them. Very often it could be, sweet little assistant in HR, and they're interviewing, a fire chief who's been around for 30 years, and you can tell who thinks they were running the show. And so that's just an example, not stereotypical. I'm not trying to stereotype, but I've seen those types of situations where plainly the witness thinks they're in charge. And so make sure that you control your interview, but do it in a respectful way. By that same token, if your witness does not answer the question, then ask it again. I read investigations literally all the time where the witness is just dodging and they won't answer the question, and they're all around going in circles, going in circles, going in circles. Ask it over and over again. And at some point you may have to say, you're not answering my question, I'm going to ask it again. Be very clear, because if it's an important issue, you've got to get the answer. If the witness says something doesn't make sense to you, ask them to explain it. And then this happens a lot. If they say, oh, I don't remember, because often if they don't want to be real candid, that's an easy way for them to start. Oh, let me just say I don't remember. If they let me off on that, then they're good. They haven't lied exactly maybe, but they got off from having to really give truthful, candid testimony that might be uncomfortable. So if they say something like that, ask them questions like, well, is there anything that would help you remember? I don't remember what time it was. Well, do you remember if it was before you had gone to lunch? Do you remember if it was before you took that vacation in June? Do you remember, if it was after you had received your promotion? Give them some time parameters, give them some events as milestones, and see if you can't get them to hone in on timing, on details that they're going to maybe try to suggest they don't know or don't remember. Sometimes that can be a helpful interview technique. A few more things on questions. When you think you've exhausted a line of questioning, so if there's, typically there's events that have happened. So if it's sexual harassment, then there's this event where, a supervisor, brushed up against me, and that was offensive. So, you've talked through the whole encounter, what happened from the beginning to end. When you think you've got everything that that witness wants to say about it, I think it's helpful to confirm it back. So let me just make sure I'm clear, but I think I understand that you're saying that about 9 o'clock that morning, this individual came in. When he opened the refrigerator door, he leaned back, he pushed up against you, he touched your breast, and then this encounter hurt, and and you go on from there. Confirm it back, and then if they agree with you, then you've condensed it all into a manner of questioning that you can then use very effectively when you're doing your ultimate written report. I think that's a wonderful technique. Exhaust the questioning and then confirm it back. And then before you let the witness conclude, I think this is important. Ask the witness these questions in my bullet point number 2. Is there anything, before concluding, ask, is there anything else that you think is important for me to know? Do you have anything else to add? Is there anything about your answers that you need to clarify? That's a really good one, because many times later, someone will say, well, that's not what I meant, or they didn't ask me about this, or they took my, answer out of context. So you give them an opportunity to clarify anything that they think is unclear. Ask them who else you think has information that should be included in this investigation. Who else should I talk to? And what records might you think I should look at? Do you have any text messages? Do you have emails? Do you have voicemail recordings? Ask it to everyone. You never know. And then direct the complainant, the target, and every single witness that they are to have no contact with each other and no discussion of the investigation. And I think it's actually helpful to put that in writing. So when you're scheduling the interview, or either you do it as a conclusion of the interview where you hand them a piece of paper that says, thank you for participating in this interview process. You will not be subject to retaliation for your participation. There should be no contact and no discussion. And when you put it in writing, I think that's the best way, because very often they will violate it the minute they step foot out of that interview room. They'll go and they'll call somebody. Well, here's what they're going to ask, or what do you think about this? Or they'll let the complainant know, or they'll give a heads up to the target employee. So many times it's the things that happen during the investigation that are more clearly what gives rise to disciplinary action. So be mindful of that, but it's very important that there's no contact, no discussion, because that can really, really taint your investigation. And also it can really create a morale issue within your department where this investigation is taking place, because obviously you need everybody to keep working. You need things to keep going on a positive manner. And if people are talking and grumbling and gossiping, that's not going to be able to happen, not be effective. So as a matter of follow-up, after you complete a witness interview, determine if there's any additional questions that you need to go back to other witnesses. If you see that Sally said this and Jane said this and they don't line up at all, then you may need to go back to one or the other of them and try to see if you can reconcile those contradictions. It's perfectly fine to have subsequent interviews. I mean, at some point you're going to have to draw a line, but I don't think you need to feel wed to the fact that I've interviewed them once and I can't go back. Your next interview, though, could be as simple as getting on the phone and having a really quick call. You can still record that. You can still have another person present, but you could do a quick conference or a quick Zoom, something that gets to just a couple of questions as opposed to the full interview. And you can do that as much as you need to do it to ensure that you're getting to the bottom of the issue. I spoke a little bit ago about documentary evidence, but I'll just make another comment here. Documents, whether it be emails, texts, fax messages, any other written communication, notes, sticky notes that are, placed around. Sometimes, there's photographs that have been posted that are part of a sexual harassment or discriminatory harassment allegation. You need those actual documents. You need the picture. This picture was put up on a bulletin board. I'd like to see that picture. Ask about video footage. You know, if you have office space that is under video surveillance, you need to check that. You know, that may be under your control and not the employees, but you need to know what your resources are with respect to those types of things if you have internal cameras in your organization. Consider things like electronic key card swipes, time clocks, vehicle GPSs, cell phone records. All of that's likely under your control as the county supervisors, and you can identify sometimes some untruthful statements there, or if it's not untruthful, but they just can't remember to time certain issues and how things happened, or locational issues, then you may be able to get at them with some of these other types of evidence that you can generate on your own, even if they don't suggest them, or even if they don't think about them. And then the other big white elephant in the room on these investigations very often is social media. You know, you can ask folks if they've seen social media posts related to these issues, but you're also certainly welcome if people have open, you know, accounts to look and see if you see anything that lines up with the allegations. I mean, I've had situations where, you know, there's an allegation of sexual harassment, and you know how they're scared of this supervising employee who's done all these bad things. You go on their social media site and you see that they're at dinner together and they're here in this group and they went on this hike together, and it just doesn't seem to completely gel. And it's just, you know, may not be the be all end all of the evidence, but maybe something that's useful for you to know by looking at or asking about social media. I know I'm coming close to my time, so I'm going to try to whip through these last few slides here. Let's say you've completed the investigation, and now you got to figure out what to do with it. So you may have a mile-high stack of interviews and documentary evidence and all of this information, and sometimes it can be incredibly overwhelming to distill all that down into something that you can then move forward with. So the analysis piece of it is incredibly important. Sometimes I think the most basic, easy thing to start with is make a timeline. You know, if there's several different events that are alleged throughout a harassment period, you start with the timeline. You may realize when you create a timeline and you start plugging in sort of key facts based upon your witnesses that you have some gaping holes. And so that may be the point in time where you realize, okay, I've got to do some follow-up, or someone mentioned a record, I never got that record, or maybe somebody never followed up to produce that document. I've got to do that follow-up. That will help you then to resolve any lack of clarity or any contradiction. Once you really have the basics of here's what happened, here's when it happened, here's all my records about it, then you're going to want to review your relevant workplace policies, because you may see that when you review the policies on any particular relevant issue, that shows you that, okay, here's another gaping hole that I need to see if this element was present in what happened, and that may cause you to go back once you've analyzed it and realize you need to do some fill in the blanks with additional interviews or with additional record gathering. Ultimately, though, your hope is, and your plan and your goal is to get through the investigation, to get through that analysis, pulling it all together, and then be able to produce a written report. I will tell you that I have some clients who have come to me and they do the investigation, they have all the raw data, and then they want me to assist with writing a report. That can be an effective use of an attorney or some outside party who reviews the findings. So that could, you know, be your additional neutrality for you as well. Or perhaps it's someone just advising you. It could go either way. Your written findings should have facts and conclusions. It's not helpful just to have a recitation of everything that happened. You ultimately need to have a conclusion section where you determine if the complaint was substantiated or if it was not. You may need to refer to employee handbook policies when you're considering how to do that and what the violations were alleged to be. When you get a complaint, they may not say, this employee has violated Rule 2.502, but you need to hear what they say. You need to know what policy violation may be in place, and then you need to make sure that you're considering that when you ultimately issue this report. If you're not able to conclude what happened, then you just need to say that. You need to say, you know, there was a variety of different responses and testimony on this point. I could not reconcile the contradictions. I think that's fine. I had a sexual harassment a lawsuit, investigation not so long ago, and it was very much he said, she said. Even the witnesses were contradicting. There was no way to know what had really happened. But interestingly, in the course of the investigation, there were other things that occurred. There was some untruthfulness that happened, and that ended up being where the investigation landed, where it was a termination based upon untruthfulness in the investigation. But the ultimate investigation report concluded that we can't substantiate, affirm, or deny because of the conflicting testimony. So it's okay to say that when you've done everything you can to get to the bottom of it. Don't speculate. When you do that, there'll be a lawyer down the line sometime who brings that claim, and they will eat you alive on it. So make sure you state the facts as they've occurred, state the conclusions that you reach, but don't speculate. Don't try to fill in blanks without the factual testimony. Make sure you can support your conclusion with your specific facts. And here's a really big point I want to emphasize here on the written reports. While you might reference your policy violations, I beg of you, don't make legal conclusions. I get investigations all the time where they say the employee committed sexual harassment or the employee created a hostile work environment. Well, it could be that the employee's actions violated your policy on sexual harassment or your policy on hostile work environment. But don't make a conclusion that is as if the legal claim has been violated. The reason I say that is because remember that your complainant may become your plaintiff with a claim against the county. So if they bring a sexual harassment allegation that you investigate, well, hopefully you're going to get to the bottom of that. If something went wrong, you're going to take corrective action, and that employee will be happy with the results and will march right along. More times than not, though, that is the beginning of what will be a lawsuit. And so that complainant makes the complaint because they have to go through the process, but ultimately they're a plaintiff, and everything you say is going to be used against you in a lawsuit. So it's really between a rock and a hard place, because when you're supporting the disciplinary action against that target employee, or you're making your findings in your investigation that really find that the complaint is substantiated, you may well be making evidence for that complainant in their claim against the county. So it's really, it may sound like semantics and it's very nuanced, but I would say focus on the facts, focus on a policy violation. But just because it violates policy, or because it may be a zero tolerance situation in your county or your city or your organization, doesn't necessarily mean it rises to the level of the legal claim. And without getting too far into that, let me just give you an example. So, you know, under sexual harassment, the legal standard is the conduct has to be severe and pervasive. So there may have been an inappropriate joke told, or some inappropriate picture posted, or something that you say, we do not tolerate that, you're in violation of this policy, and there's going to be a disciplinary action. But if there's one joke or one picture, as the defense attorney trying to defend the county, I'm going to say that's not sufficiently severe and pervasive to have resulted in a legal claim of sexual harassment. County's not liable. So I hope you can see sort of the distinctions there, where it may not be tolerable conduct, but it may not rise to the level of a claim for which the county should get out its checkbook and be liable for. But if you get an investigation that makes these grand and global conclusions, legal conclusions, then you can really tie the hands of your lawyer later on to argue that, oh yeah, well, the investigator said it was sexual harassment, but they didn't really know what that meant. They didn't understand it. And then you're diminishing the impact of that investigation to say, no, they were wrong about that. It's really not sexual harassment because under the law, here's what that means. So be mindful of that in your written report. And then just as a final matter, your conclusion, the ending of it, I like to feel like you tie it up with a bow. You want to communicate the conclusion to the complainant and to the target. The report should be provided to them, but I would limit it only to the complainant and the target. All the witnesses don't get it. Ultimately, it's going to be subject to open records at a certain time period, but you don't need to just pass it out. But I do think the target and the complainant are entitled to see it. And then what happens next? So now you know what you know in terms of all of the information you gleaned in the investigation. You've determined whether it was substantiated or not, whether there's a violation that needs to be addressed with disciplinary action. But then you need to not fumble on the 5-yard line. You need to take it over the goal line by ensuring that the post-investigation actions are appropriate. Take corrective action if it's necessary and if it's appropriate, but also feel comfortable if it's not substantiated to not take a corrective action and to make that finding. If you do that, that doesn't always mean that then that complainant has brought a false charge. I mean, sometimes it could be a good faith charge and you just didn't find supporting evidence. Doesn't necessarily mean it doesn't happen, but meant that you couldn't prove that it happened. So don't necessarily believe that if you conclude in favor of the target employee that that means the complainant is bad and should be disciplined. And be careful, because that's going to look a lot like retaliation, unless you find that the complainant was untruthful. And in that case, then you certainly should deal with that. Be mindful, and we're going to talk about this more in the next segment about disciplinary action, but your corrective action can mean a lot of things. It may include training. Sometimes I think when you're most responsive to the issue, that's your best type of corrective action. So, just suspending someone and sending them away, that's okay, and it probably should be done in some circumstances. But if they're not going to be fired, then consider training, sensitivity training. Put them on a performance plan. Consider things to make sure that they're a better employee and that this doesn't happen again if they're going to stay in the workforce. Some cases are going to warrant dismissal, and you handle it that way. But if they don't, then be thinking of creative ways to ensure that the corrective action matches responsibly what the conduct was, so that you can ensure that you're remediating that employee. And it's important for that target employee, but it's also important that you can show your complainant what you're doing. Because if in fact it does happen again, then you want to show that you weren't blind to trying to effectively remediate. And then if that target employee engages in additional problematic conduct, then probably it is going to lead to a dismissal consideration. I think it's important to follow up with the complainant. So say you complete an investigation, maybe a month down the road, just do a check-in. How are things going? Hope everything's well. Give them an opportunity to let you know that things have been positive. And then document everything. If you do follow up, obviously if you do corrective action, you want to document every bit of that and ensure you have your file clean and complete. So with that, I will entertain questions. I know we are a little bit over the 3 o'clock. Dan and I decided on the front end that we wouldn't take questions throughout the presentation, because this is sort of a topic that I know there's going to perhaps be a lot of questions, and we just didn't want to, infringe upon anybody's time if you were committed to this one little hour of availability. But at this time, I will stop talking, and I will ask Dan if I have any questions. I'm happy to stay on and help anyone with anything particular that they might want to ask me. Otherwise, let me say it's been a pleasure.
Great job. Thank you so much. A few questions here.
Okay.
You have sample policies to share.
I can. Let me look and see what. I don't have a template that I say this is my perfect policy, but I've written a lot of them. I will say that in my experience, because I write a lot of handbooks, that each jurisdiction very often has sort of a really strong opinion about how these things work. And who does the investigation. So I'm happy to share with Dan some general policies, but just be mindful that you may need to plug and play a little differently based upon what your organization is, based upon how your grievance procedure works. So if you look at an investigation template that I may give you that has it being investigated by the county manager, but as I mentioned earlier, if the county manager is your ultimate decision-making body on a grievance process, then you may need to change that. So happy to do it, but just want you to realize those limitations. But also you could, come back to me and ask me specifics if you need to about your organization. But happy to get you out some policies. Just wanted to have that caveat that it's not always one size fits all, but I'll give you some guidance.
And you guys are always open to being hired as county or city attorneys, right?
Of course, of course.
So should we ever not give the name of the complainant to the target employee?
That's a great question. I think the employee probably would love to say, I would like to be anonymous and I would like to have this be confidential. So I see this target employee doing these bad things, but I don't want to be on record. That's a difficult thing because I think when you go through an investigation and ultimately, particularly when you do an investigation, it could be leading to some kind of disciplinary action, some kind of adverse action against that target employee. The target employee has some due process rights, is what we would refer to it, to understand who their accuser is. And so I don't think it's a great idea ever to protect and to promise a complainant that their name will not be shared. We've got that Georgia Whistleblower Act that if it's allegations about waste and fraud and so forth against the government, that there can be a protection of making that name public. But I think you just have to be real careful with that. Most of the time, it's going to be obvious because if it's a sexual harassment or discriminatory harassment, it's about this one-on-one conduct, and there's almost no way not to involve the name of the party because you can't otherwise ask the questions. But I think that's a very, very case-by-case decision about how you can handle that. But being mindful that you've got obligations to protect under the Whistleblowers Act, you've got just general obligations that you don't want to, make an employee complainant more uncomfortable than you need to. But then you do have an obligation to that target employee who has rights too. So I wouldn't take anonymous complaints. I wouldn't launch investigations based on anonymous tips. I think you need to have a written signed statement. And then from there, whether you disclose that in full to the target employee in the beginning or not, I think you have to look at that on case by case.
How can you determine whether administrative leave should be with pay or without?
Well, that's a great question. So my typical recommendation is to put them on admin leave with pay. Just because you're doing the investigation, you're controlling that timeline. And so, and everyone should be innocent until proven guilty, right? And so if you get a complaint and you send an employee home, it's very easy for that employee then to have a claim, particularly if it turns out the investigation is not substantiated because they've lost this pay. Now, you could do this. You could put them out on leave without pay, and then if the investigation concludes in their favor, then you can do back pay. I've seen some situations do that. Frankly, if it's like a drug and alcohol violation where you've had a positive test, that's not really an investigation process, but on those type things, I do say put them out on leave without pay because you've got some objective data that says they violated policy. If that negative or positive drug test is ultimately proved not to be problematic, then you do your back pay. But in these types of investigations, you probably don't have that kind of objective data. Now, if it's not an allegation-based investigation, but it's an investigation that is commenced because the supervisor has seen misconduct and wants to just get more detail on it before taking the disciplinary action, like if there is some good objective data that a violation of something has occurred, then I think that could be a different story, and I think you could put them out on unpaid leave. But I think the unpaid leave component, you have to be careful that it's not punitive, because even if you're going to back pay it, if someone loses pay for 20, 30 days, that can be really debilitating. And so in my experience, it's better just to pay them. That'll motivate you to move your investigation quickly. But also what's important there is that it's going to make sure you don't end up having a claim from that target employee too, because you can get hit from both sides. And I think that's just an opportunity to avoid that. But that's where also, just to circle back one more point there, is if you have a situation where you can transfer that employee, if you have needs within your organization, maybe it's as simple as, gosh, the receptionist is out. And so you're going to move them from that admin position and put them over at a different building, and they're going to answer the phone in the parks department while that person's out on vacation. If you can keep them employed, but separate them from their complainant, that would be my first goal, because then they're getting paid, but they're producing some value. And certainly if it's law enforcement or fire and you can put them on different shifts, or different stations, that would be my first choice as well.
Do you purge the investigation from the personnel file if it was unfounded?
No, because It's as soon as you write down anything on a piece of paper as a government employee, it's subject to the Open Records Act. So you cannot purge documents under the Open Records Act, except if you've done them, proceeding according to a record retention schedule, which is, there's a litany of record retention laws promulgated through the Secretary of State's office. You have to retain records depending on what kind of records for a certain period of time, years, most cases. So no, not as a matter of course do you purge. Now, what I think is important, just so it's not a stigma on an employee, is if it's unsubstantiated. I mean, the complaint it's like, where do you put it? So, I've had some clients who will keep IA files separate from personnel files. I think that's a fine thing to do. That way, if someone asks for the target employee's investigation file, it was unsubstantiated, so there's no disciplinary record, they'll get that personnel file and they'll have no idea an investigation was ever done. And I think that's a fine way to do it. Or, the investigation, if it's unsubstantiated, it could go in the complainant's file. So it doesn't necessarily have to go in the target employee's file. But I think probably the better practice is having a set of IA files that you keep in HR based upon the complainant's name and target's name. And if anything ever comes up, sometimes you may get an Open Records Act request that asks for every record related to this employee, and then it is going to be subject to production. But I don't think you necessarily have to dump it into their personnel file to create a stigma, particularly if there's no ultimate disciplinary action and it's unfounded. But don't just trash it. You can't just throw it away.
And the last question at this time, and maybe a sample investigate, or they want a template investigation report to share. So along with the policy.
A template investigation report. Okay, I think that is super hard too, because it's so case by case. Let me see what I can come up with on that. Let me look at some that have been done. I tend to review them more than I write them. And so I don't know if I have one that I feel like would be a great template in the HR context. So let me just think about that. I'll put that on my list. What I might be able to do is give some template guidelines about how I would, try to format it. So I'll try to do that and try to use, at least give you some kind of formatting guidance to try to be helpful there.
Got a comment? This was a great session. Any other comments? Any other questions? Well, we're about 3:20, so we have extended our webinar, but really want to thank Angela. Fantastic job as always.
Thank you.
Everyone else, thank you all for participating. As I said at the beginning of the webinar, I will be sending out a link to the recording, the PowerPoint presentation, and if Angela provides those to me, a couple policy templates. So we'll go from there. I thank you so much. Everyone have a great rest of the week, and go Dogs.
Go Dogs. Thank you all. Great to see you this afternoon, and join us next week for disciplinary actions, the do's, don'ts, and what if you don't. Hope you can join us. Thank you.